Hello and welcome to a new episode of Buzaker Law Firm podcast. So much to cover today, and therefore, without further delay, hello Valeria Buzaker.
Hi, how are you?
Not too bad. How are you?
Good.
And as usual, just before we begin, 10 seconds for this.
So as always, our disclaimer. The information provided in this series does not and is not intended to constitute legal advice. Instead, all the information is for general information purposes only.
Thank you for that. Valeria, what are we going to discuss today?
So today I want to touch a topic that concerns all of us, which is small claims court. I believe that there are many reasons to have a justified cause of action to sue for damages and or other debts. Many people refrain from doing so because they're concerned. They have the mistaken notion that such a claim cannot be filed, whether because the amount is too low or because there are some related costs or it seems for them too complex. So as we will see further in today's episode, the reasons are not really accurate, to say the least.
And for that purpose, we have today again with us Mr. Matthew Foghi. Hi, Matthew. How are you?
Hi, how are you?
I'm great. Thanks for being with us again.
Thanks for having me here.
And for those of you who doesn't know Matthew yet, he's an associate with Buzaker Law Firm. He's an experienced paralegal specializing in small claims court. But not only, he's also a licensed real estate broker. So Matthew, I think you can tell us a little bit more about small claims court today.
Yes, I will. So to start with, allow me to provide you some basic information. As you might be aware, prior to year 2010, monetary claims limit handled by small claims court was $10,000. Between the year 2010 and 2019, this limit increased to $25,000. And the good news is that as of January the 1st, 2020, this limit has increased to $35,000.
Wow.
This is certainly a great news for Ontarians. The cost of processing a claim at small claims court is significantly lower comparing to higher courts. Small claims court cases are processed much faster compared to higher courts. And in addition to that, the amount of claim that can be appealed to divisional courts has increased from $2,500 to $3,500. Litigants who are processing their files in higher courts can now transfer their claims to small claims court if the threshold of the claim falls within the limits of a small claims court. And the final information that you might be interested to know is we have 77 small claims court across Ontario.
Which makes it pretty easy to find one that's not too far away from you.
Yes, correct.
It's definitely very exciting news for all of us.
And the next question is naturally, what are the causes of action one can claim for?
So we have the monetary claims under written or verbal agreement. I'll give you a few examples. Unpaid accounts for goods or services sold or delivered. The example would be, for example, a realtor provides a service to a homeowner or to a buyer, but he doesn't get paid for his services. I should also add that a service provider can be anyone. It could include an individual, a company, trades, contractors, renovators, electricians, plumbers, private teachers, healthcare providers, just to name a few of them.
Podcast editors.
Podcast editors could be if they are not paid on time. Yes, another category of the monetary claims could be for unpaid loans. As a creditor, you provide a loan to a friend, to a family member, or to someone who is in need of loan, but you don't get paid. It can also include unpaid car loans, unpaid line of credit balance or credit card balance, all up to $35,000. Also, I should add another category, unpaid rent, for some tenants who have left property before their files are handled in landlords and tenants board. There are other options for the landlords to go after those rents within a small claims court. Finally, your monetary claims can be unpaid utility bills, unpaid equipment or car rentals, and so on.
Okay, I think the picture here is pretty clear. And you're talking actually about monetary claims. I know that there are also other kinds of claims that one can refer to small claims court, such as damages, for example.
Yes, if there is no specific predetermined price tag on a claim, such as a dishonored check that doesn't have a specific price, then you will file your claim under the damages. It can include property damages, breach of contract, personal injuries. To give you an example of personal property damages, for example, your neighbor's tree falls down and damages your property, a mechanic damages your car while trying to fix your car, or a faulty wiring by an unlicensed electrician causes some significant damages to your property. Breach of contract, you write a contract, you write an agreement, the party on the other end promises to act and perform in a certain way, but he doesn't. He doesn't start the job on time. He frustrates the contract to the point that you don't want to do the work with him. Or a service provider, a renovator comes to your house, for example, and does a poor workmanship. They are all causes of action under claims for damages.
Is it true that you have to have an agreement in place in order to have an option to have a claim?
It is true. The agreement can be both a verbal and written agreement. Obviously, if the agreement is verbal, you have to work on it. So you have to make sure that you can show to the decision maker that there was a process, there was an agreement in place. It is harder. So it's encouraged always to have an agreement that is written, but it's not end of the game. So you can always have a verbal agreement and claim your cause based on a verbal agreement with the other party.
I think it's very important for all our listeners to be aware of, because it seems that everyone is doing renovations these days.
Absolutely. And the intention initially is that both parties trust one another. They show good intention. But as the work goes forward, the problems appear, more work needs to be done. They can't agree on the terms, and all the frictions and problems start.
One thing is for sure is that you have to have proper presentation and proper consultation before you even dive in. You have to remember that you will be judged by the claim with the evidence that you have in place. So definitely having a proper consultation before can save you a lot of time and effort and, of course, money. And this is why we are here for you.
Yes, correct. Having a judgment is first step. Once you have a judgment, obviously, if the person voluntarily obeys the judgment and pays the debt for the damages, it's good. But there are many occasions that the people are not paying for the damages voluntarily. So that's the time that you have to enforce those judgments.
So therefore, for the enforcement, seems that there is a big topic ahead of us. So stay tuned for our next episode where we will discuss it in details.
In the meantime, Valeria Buzaker, Matthew Foghi, thank you very much for being with us this time.
Thank you.
Thank you very much.
And see you next episode.
See you next episode. Bye-bye.